Before most Americans even woke up this morning, the Supreme Court quietly changed how power works in the United States. No warning, no public debate, no televised arguments, just a sudden 6-3 emergency ruling that will begin affecting millions of people as soon as next month. And here's the part almost no one is telling you yet. This decision doesn't just alter a single policy or resolve a narrow legal dispute. It fundamentally changes how your rights are protected in this country. Whether you realize it or not, the legal ground beneath your feet just shifted overnight. This isn't just another Supreme Court headline. This is a tectonic realignment of power between judges, presidents, and the American people. In state capitals, federal agencies, and courtrooms from Washington, D.C. to California, the rules of the game were rewritten in a matter of hours. And most people have no idea what just happened. Before we break down the details that are already sending shockwaves through the legal system, make sure you're subscribed, because this is exactly the kind of Supreme Court decision that doesn't just feel real until it hits your life directly. Late last night, the Supreme Court released a 6-3 emergency ruling in Trump versus Cassa, Inc. through what's known as the shadow docket. That means no oral arguments, no months of deliberation, no full public briefing, just a rapid decision that immediately reshapes the legal landscape. The case itself involved a high-stakes executive order tied to birthright citizenship. But the court used this case to do something much bigger. It settled a decades-long internal war over judicial power that has been quietly building behind the scenes. At the center of this ruling is a concept most Americans have never heard of, but have relied on for decades: nationwide injunctions. The Supreme Court just ruled that federal judges can no longer issue universal injunctions that block a law or policy from being enforced across the entire country. And while that may sound like technical legal language, the consequences are enormous. This single decision rewrites how constitutional challenges work in America. For the last 25 years, when someone challenged a law they believed was unconstitutional, a single federal judge could temporarily stop that law from being enforced anywhere in the United States while the case worked its way through the courts. One judge, one courtroom, one order, and the entire federal government had to hit pause nationwide. That power was used in immigration cases, healthcare disputes, environmental regulations, gun laws, workplace rules, and voting procedures. A judge in California could freeze a policy in Texas. A judge in Texas could block a rule from taking effect in New York. That era is now over. The Supreme Court didn't just limit that power, it destroyed it. According to court filings reviewed this morning, there are currently 68 active nationwide injunctions affecting everything from prescription drug access to workplace safety and election administration. Under this new framework, many of those injunctions could collapse within the next 60 to 90 days as lower courts scramble to revise their orders. And the timing could not be more explosive. We are heading straight into an election year with major fights over immigration, healthcare, civil rights, and voting rules. This ruling just changed how every single one of those battles will be fought. The majority opinion was written by Justice Amy Coney Barrett and joined by Chief Justice Roberts, along with Justices Alito, Gorsuch, Kavanaugh, and Thomas. Their argument rests on a simple but radical claim. The Judiciary Act of 1789 never gave judges the authority to protect people who aren't actually parties to a lawsuit. According to the majority, a judge's role is to resolve specific disputes between specific people, not to act as a nationwide veto over presidential or congressional action. But the most explosive reasoning didn't come from the main opinion. It came from Justice Gorsuch's concurring opinion. He traced court practice from the founding era through the late 1800s and found something remarkable. American courts did not issue injunctions protecting people who were not directly involved in the case. Judges repeatedly refused to extend relief beyond the actual plaintiffs standing in front of them. Justice Thomas went even further, arguing that nationwide injunctions are a modern invention that encourages forum shopping, where advocacy groups hunt for sympathetic judges to shut down policies they oppose. According to the majority, that era is now officially over. The dissenting justices saw this very differently. Led by Justice Sotomayor, they warned that stripping courts of universal relief gives the executive branch the ability to enforce unconstitutional policies, while individual lawsuits crawl through the system. They argued this ruling risks turning constitutional rights into privileges reserved only for those who can afford to sue, and that I'm where Part 1 ends, because the real impact of this decision isn't theoretical. It's already unfolding in real time across immigration, gun laws, healthcare, elections, and the economy. Within 48 hours of the ruling, the legal landscape shifted dramatically. Attorneys general from 18 states filed emergency motions in federal courts, attempting either to preserve existing injunctions or to immediately enforce laws that had been frozen for years. Texas moved aggressively to narrow injunctions blocking immigration enforcement. Florida filed emergency briefs targeting social media regulations and election procedures. California and New York countered with filings of their own, desperately trying to preserve nationwide blocks on federal policies they oppose. Behind the scenes, the Department of Justice convened emergency strategy sessions with hundreds of federal attorneys across dozens of active cases. The White House Counsel S Office quietly warned federal agencies to prepare for laws they believed were blocked to suddenly take effect, possibly within weeks. The speed and scale of the reaction tells you everything. Legal strategists view this as a massive power shift toward the executive branch and a devastating blow to judicial resistance. Advocacy organizations on both sides of the political spectrum are now scrambling. Groups like the ACLU, NACP, and Alliance Defending Freedom relied on nationwide injunctions as their most powerful legal weapon. That weapon is now gone. Major law firms are warning clients that civil rights and constitutional litigation could now cost 5 to 8 times more, because instead of filing one lawsuit, plaintiffs may need to file in dozens of jurisdictions. This is where the ruling becomes deeply personal. Immigration enforcement is ground zero. There are currently 19 injunctions limiting ICE practices nationwide. Under the new framework, those protections may only apply to specific plaintiffs in specific districts. Immigration enforcement could now look completely different depending on where you live. The same is true for gun rights, healthcare access, environmental protections, workplace rules, and voting laws. Your rights may now depend on your zip code. We are potentially entering an era where federal law exists on paper but is enforced unevenly across the country. 50 versions of the same law, one constitution, but fragmented protection. As we move toward the 2026 election cycle, this ruling sets the stage for unprecedented legal chaos. Election administrators are already warning of a nightmare scenario where voting rules vary not by state law, but by court geography. Corporate America is also panicking. Multi-state companies are now facing the prospect of complying with different federal rules in different regions. Banking, healthcare, technology, and pharmaceutical industries are all warning of massive compliance costs and regulatory confusion. Estimates suggest this legal fragmentation could cost businesses tens of billions of dollars annually. But this story goes even deeper. This ruling is part of a broader Supreme Court strategy that relies heavily on the shadow docket, where high-impact decisions are made without full briefing or explanation. By issuing emergency orders that effectively reshape the law, the court is asserting control over lower courts in ways that were unthinkable just a decade ago. Critics warn this creates a chilling effect, where judges hesitate to block even clearly unconstitutional actions for fear of swift reversal. For civil rights, the implications are profound. For decades, broad injunctions were the primary tool used to dismantle systemic discrimination. Now, courts may only protect the handful of people who sue, leaving thousands of others exposed unless they file their own cases. Justice Jackson called this an existential threat to the rule of law, warning that it creates zones where the Constitution effectively doesn't apply. The Supreme Court's 6-3 emergency ruling in Trump v. Cassa, Inc. didn't just change a legal procedure, it changed the meaning of protection in America. If your right to vote, to equal protection, or to due process only exists if you personally have the resources to sue, then those rights begin to look less like guarantees and more like privileges. We are entering a new era of American law. Whether this represents a return to constitutional originalism or a dangerous fragmentation of justice depends on your perspective. But one thing is certain. The legal patchwork is here, and its consequences will define immigration policy, elections, civil rights, and economic stability for years to come. If you want to stay ahead of these changes, make sure you're subscribed, hit the like button, and tell me in the comments, was the Supreme Court right to end nationwide injunctions, or did it fracture the rule of law? Your answer may say more about the future of America than you think.